calling our second case, People versus Jade. This is also a 20-minute grant. Mr. Gentleman, you have 2 minutes of fire-free zone, and you may reserve any time that you would like for rebuttal. We just ask that you keep track of it.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. Tim Doman on behalf of Jayneel Jade. I'm joined this morning at council table by my co-counsel, Scott Grable. I will try to reserve 5 minutes for rebuttal, and I'll keep track of my own time. Your Honors, when we talk about entrapment, I think just as important as defining what entrapment is defining what entrapment is not. Entrapment is not a duress defense. It's not a voluntariness defense. It does not require the defense to show that the defendant's will was overborne. If we go back and read the foundational cases from this court, the United States Supreme Court, the crux of entrapment is really about stopping police from manufacturing crimes that otherwise would not have occurred. And the gist is really that we want police investigating real crimes, catching real criminals, rather than creating crimes for the sake of arresting and prosecuting people. So to me, as I read the case law, really the central question in any entrapment case is, were police manufacturing a crime that the defendant otherwise would not have committed? And I think all the different tests for entrapment, subjective, objective, and all these different maxims about mere opportunities and hypothetical law-abiding people and the 12 factors and all that, I think those things were originally designed to help us answer that central question about manufacturing crime. But at the same time, I think they can also serve to obscure the true meaning of entrapment and lead the lower courts astray, which I think is what happened in this case. And so that brings me to the second question that this court asked the parties to address, and that is whether the Court of Appeals erred by applying the standard that a mere opportunity to commit a crime is not entrapment without also considering readiness and willingness. And obviously, to me, the answer is yes. In People v. Jamieson, the case that this court cited in its order granting leave, the court said, quote, "There is no entrapment if a policeman merely furnishes an opportunity for the commission of a crime by one ready and willing to commit the activity." And I don't think you can take ready and willing out of that maxim, because we have cases from this court and other jurisdictions where a mere opportunity.
Counsel, good morning.
Good morning, Your Honor.
I'd like to just keep things simple and go right to the point. This was a website that was designed for adults, was it not? It was an adult website.
Correct, Your Honor.
So ultimately, the defendant in this situation went to a website where he believed he'd be engaging with adults. That was his intent, was it not?
It was, Your Honor.
Okay, thank you.
All right, thank you. And so, as I say, I don't think you can take ready and willing out of the mere opportunity maxim. And I think the late Justice Kavanaugh put it well in Jamieson when he wrote that a mere opportunity to commit a crime can be entrapment if the opportunity would not be normally presented, or if it requires the police to engage in some type of immoral acts. And I believe the prosecutor agrees with me, because they cite that quote in their brief as well. So if we recognize that a mere opportunity can be entrapment, I think that means that we always need to assess the ready and willing side of the equation. In Mr. Jade's case, obviously that didn't happen, in the Court of Appeals at least. The Court of Appeals decision is really replete with references to this idea that a mere opportunity to commit a crime is not entrapment without also considering ready and willing. So I think it's clear that the Court of Appeals in this case erred in how it applied this court's entrapment jurisprudence.
Counsel, what do we do with the fact, on the ready and willing point, with the particular facts of this case where perhaps his comment that that she needed to be at least 16. And in fact, he was charged with CSAA, which also requires it to be under 18, right? And so there's the comment of you have to be at least 16 is still, isn't it not indicative of a ready and willingness to commit a crime still? Because this person, like, willing to do it, she's 16, but that's still under 18, that's still a crime.
Right, Your Honor, so that's a great question, and I think two answers. Number one, under the objective test, we really need to be looking at what was the police conduct, and ready and willing under the objective test asks, was this police conduct designed to catch only those who are ready and willing to commit the crime? And that is, we look at that without reference to defendant by defendant analysis. The other thing is that, to me, ready and willing means what was the defendant's intent before he ever crossed paths with police. And so here, his intent was to solicit a consensual adult interaction. The question is not, did he become ready and willing to commit a different crime once presented with a different opportunity? We have to go back to what was his original intent and how that was manipulated by police. So, I think when we talk about, well, wasn't he ready and willing to commit this crime, it starts to look a lot like predisposition, is my point, which we're not supposed to assess. So I think that line of thinking takes us somewhat dangerously close to the subjective test.
So, counsel, what would be a valid operation here? You know, I mean, I know, like, I assume you would be okay if they were on some dark website where,
Right.
you know, it's known that everybody's underage. I think that's probably a easier line.
Right.
You know, so let's assume they're still on Skip the Games. What would have been, is there anything they can do on that site that's legal with a decoy?
Yeah, I was thinking about that, Your Honor, and I think part of the problem is that Skip the Games is so explicitly designed for adults only. They have all these disclaimers about it's only for adults. If we catch wind of anything else going on, reach out to us. We don't need a subpoena or a search warrant or anything like that. Now, if at some point it becomes clear that those disclaimers are all lip service and everyone knows and we have evidence that this is the go-to place if you're looking for an underage escort, it could be a different situation, but we don't have that in this case. And it was also interesting to me looking at the videos that CDAM presented, because in addition to these types of sting operations, Genesee County is also doing what they call rescue operations, where they're essentially trolling these websites looking for actual children being trafficked, and then they go out and rescue them. To me, there's zero problem with that. That's what they should be doing. So frankly, I think the resources should go toward those types of operations rather than these.
Counselor, there's some indications in this particular case that there are standards or best practices around these police stings. You know, there's a recording, there's training of a decoy, there's having the defendant be the first person to bring up. How do we look at that in the analysis? Is that part of the 12 factors? Is that something else? Like, how do we look at what should be happening as a matter of standard practice and when an investigation does or doesn't comply with that?
To me, I think that fits best under reprehensibility, and reprehensible being somewhat of a term of art in this context about what was the police's intent. Was it to catch people who they believed or had reason to believe were actually committing this crime, or were they creating these crimes for the sake of arresting people? And so when you have these kind of freewheeling operations that really have no operational constraints or do in name only that they're not following, and CDAM's brief had some really egregious instances of that. To me, that fits most neatly under reprehensibility, that they're not even following these constraints that they supposedly set out, that really their intent is merely to manufacture arrests at that point. So kind of what we touched on before about what does ready and willing mean. I think it's interesting that on page 30 of the prosecution's brief, they explicitly endorse this idea that, well, the defendant committed the crime, therefore he must have been ready and willing to commit it. if that's the test, then entrapment effectively ceases to exist, because in all these cases, or almost all these cases, we start from the premise that the defendant committed the charged crime, right? So again, I think it's crucial that we recognize the distinction of, did the defendant become ready and willing once the criminal opportunity was presented, or was he ready and willing before police ever entered the picture? And again, I think that's a distinction the lower courts missed in this case. So to me,
So Counselor, there's a lot of debate in the literature, sort of how objective or subjective this is. And so we have sort of mixed the two previously in prior cases. Is your position that ready and willingness is, an average person, or is it the defendant in this particular case? Which of those is your perspective on what this rule is?
yeah, that's a great question. I mean, under Gillette, it's a person similarly situated. So, which I think some of the dissenting and concurring opinions in Gillette suggested starts to sound a lot like predisposition as well. In Gillette, the way that was applied was to the defendant's vulnerabilities, setting aside predisposition. So really, as far as I can tell, that's the best example of when we consider the particular circumstances of the defendant without predisposition. How that plays out in practice every day, I think, is a thorny question that I hope this court will bring clarity to. So as I read the case law, ready and willing means, would the defendant have committed the same crime without police involvement? And if the answer is yes, then obviously the police have not manufactured a crime because the defendant would have committed it anyways. And I think People v. Williams, the Court of Appeals decision that I cited in my brief, is a pretty good example of that, where police targeted a high drug trafficking area. They posted an undercover police officer on the corner as a drug dealer, and waited for people to approach the undercover officer, initiate conversation, and let the suspect ask for drugs. Didn't say, hey, do you want to buy drugs? Let the suspect do all the talking. And to me, that is kind of the quintessential example of a mere opportunity that someone ready and willing would seize. The person standing on the corner did not induce the suspects to seek out drugs. I think, objectively speaking, we can assume that if this person had not approached the undercover officer, they would have approached someone else. So to me, that's a great example of this maxim in practice. Taking a step back, I want to be very clear that I believe these sting operations, or certain sting operations, are valid and often necessary to investigate these types of crimes. But they have to be designed in a way to where they're catching people who were set out to commit the crimes rather than creating crimes that otherwise would not have existed. And there's a quote from, I think it's the Hollingsworth case that was cited in my brief, that to be valid, a sting operation has to take an actually dangerous person out of circulation. Obviously, that's not what happened in this case. I mean, before crossing paths with police, Mr. Jade never had the intent to solicit an underage escort. None of the suspects caught up in these bait and switch stings had that intent. Instead, they were all seeking consensual encounters with adults. And there's really zero evidence that I've seen there that's been presented to suggest that they would have committed these crimes without police involvement. And to me, that's really the essence of entrapment.
Is it, I mean, are you asking us to draw a line, like, had the defendant respond, when the decoy said, actually, I'm under 15, LOL, had he said, no problem, or great, even better, or whatever,
Right.
Fine, clearly not entrapment, right? Like, that should, but when he said, nope, is that, once that was said, is there some obligation on the police's part to then stop? I mean, in some of these cases, less so perhaps in this case, but in some of the others where it's repeated, pursuing or trying to, even after the first no. Is it like a hard line at the first no, or the first indication of I'm not willing to commit that crime, even if, in the next text, he's like, well, okay. You know, I mean, how do we draw that line? Or is it still looking at, you know, like what our existing case law does that, and the 12 factors help us sort of draw that line in a particular case?
To me, since we have the objective test in Michigan, the focus always has to be on the police. And the case law says that proper police conduct doesn't change from defendant to defendant. And so frankly, I think even in the case where you have someone who says, oh great, you're 15, even better, I think that's still entrapment, because again, this person still.
They brought it up.
Pardon me?
They brought it up.
Exactly, it was
They
the-
made the circumstance of the crime at issue.
Correct. The person was ready and willing to engage an adult. That's why they went on Skip the Games. Whether they later became ready and willing to commit a different crime when presented with that opportunity, I think is a different question. And this is a quote from Jameson that I think I cited in my brief, but maybe I should have emphasized it more, where the court said, discretionary investigative enforcement measures extend beyond a tolerable level when, by design, the government uses procedures which escalate criminal culpability. I mean, that's this case to a T. In every situation, and really, I guess what I mean to say is the entire construct of this sting operation was designed to take people intent to commit one crime and get them to commit another crime. Under Jameson, that's entrapment, plain and simple, for everyone, I think, involved in these sting operations.
Let me try and clarify, and I think you've maybe already said this or answered it, but if your position is that even in the circumstance I described where the decoy says I'm actually 15 and the defendant says no problem, that is still entrapment because of that. So in that so is there never a circumstance on other than on an adult website or something that has been, you know, billed that you have to be, or there are protections to say you're over 18 or whatever it is, that you cannot, it's entrapment on a website like that, short of, I think you answered earlier, evidence that actually we knew that this website actually wasn't just for
Right.
adults. But when that's not the case and it's an admittedly, you know, adult-only website, the police going on there and initiating sort of any kind of conversation is going to be entrapment.
In this bait and switch context,
Yeah,
correct? I mean, if
yeah.
this were just a prostitution sting, we have no entrapment argument.
right.
So in the context of the bait and switch procedure, yes, I think that's correct.
Oh, sorry. I was just going to say, what if the defendant asked if she was under 15? Asked if she was 15? I like 15-year-olds, 14. What if they had done that on this adults-only website?
You know, I think, again, that's talking a lot of, to me, that feels a lot like predisposition, right? And the question is, was this police operation designed to only catch those ready and willing, not the circumstance of each individual defendant? And I think,
But isn't that more like the drug dealer offering drugs, just, hey, drugs for sale, anybody walking by? Isn't that a little more like they're coming in and they're the one initiating?
I don't know, because I think it was Justice Kavanaugh and Jameson or Gillette where he wrote that entrapment can occur even with someone who is ready and willing to commit the crime. And I think that's a strong point in why we need to be looking at the police activity rather than all these questions about the individual defendants, which starts to look a lot like predisposition.
I think one area where the court could help clean up the law here is on standard of review, and that's the first question we asked about. And I don't, maybe I missed it, but we really dug into that very much here. It seems to me that we could clean it up by saying, well, there's, in these types of cases, there has to be legal findings and there have to be factual findings. And when it comes to factual findings, because the trial court is there reviewing the evidence and able to judge credibility and make determinations, that is reviewed for clear error, and then legal findings are reviewed de novo. Do you have any problem with that standard?
No, that's exactly the standard I'm advocating
Okay, well,
for.
what do we do with the trial court's finding that he did not believe defendant when defendant claimed that he did not believe the decoy was 15 years old. I mean, there's this exchange, gotta be 16, no, I'm 15. The trial court concluded defendant believed this person to be 15. Isn't that reviewed for clear error?
Correct, Your Honor.
And then what do we do with that? I mean, how do we say, no, that's clear error here? When there's two instances where there's an actual, gotta be 15, or gotta be 16, and the response is, no, I'm 15.
So no, I don't think this court could call that clear. I disagree with that finding, but that doesn't mean it's clear error or that this court could find that it's clear error. I don't think this court needs to find clear error in that circumstance to decide in our favor. Because again, I think really what the trial court was talking about was predisposition under a different guise.
Okay.
So I think we need to go back, look at police conduct, apply an objective test to this, and that's where the legal error that the trial court committed comes in.
Thank you.
Counsel, you brought up Jameson, which I agree has sort of some helpful language in understanding this concept. I want to just talk about sort of this escalating criminal activity. So we have a site here where maybe there's one crime and it's escalating to another crime. How would, in your view, how would that work if this exact same thing was happening on, I don't know, Tinder or, a dating site where it's just a normal dating site? Would that same analysis apply, sort of the Jameson analysis?
That's happening right now. Tinder, Grindr, all these sites, they've moved on from Skip the Games.
Right. So that's what
Right.
I'm wondering, if that same analysis applies. We've got Skip the Games, or maybe, there's sort of one unlawful activity happening already.
Mm-hmm.
Those other sites, they are not.
And I think those sting out. I'm out of time, if I could answer
Yes,
Your Honor's
please,
question. I think certainly there's an argument to be made that those types of operations are particularly reprehensible. But I think the same analysis applies. It's a question of, were police manufacturing crimes that the defendant otherwise would not have committed? And in those sting operations, the answer is yes. These are adult dating websites. The person went on seeking, an adult for companionship. And so, I think the exact same analysis applies.
Thank you.
All right, thank you, Your Honors.
Thank you.
Good morning, Your Honors, and may it please the Court. Paige Petrosky on behalf of the people of Van Buren County, State of Michigan. Because our analysis under entrapment doctrine is focused on law enforcement's conduct, it's necessary to look at exactly what the decoy messenger had messaged defendant and how he had responded after the two had just engaged in small talk discussing the logistics of where to meet for the sex work to occur prior to the actual crime occurring. So the decoy asks, "Are you cool with younger chicks?" The defendant says, "I am." And the decoy says, "Okay, cool, because I'm 15. At this point, law enforcement has provided defendant with the opportunity to commit child sexual abusive activity, because if the defendant continues preparing to or soliciting the decoy for sex work after being informed that she is a child under the age of 18, he is then engaging in financing, arranging, attempting, preparing for, conspiring, etc., to commit child sexual abusive activity. And so in this exact moment, defendant indicates his immediate readiness and his willingness, but he also, this isn't all that he does. So, but in this instance, a hypothetical person who is interested in soliciting a consenting adult sex worker, but who is not ready and willing to commit child sexual abusive activity, would simply stop responding and end the conversation, or otherwise indicate in some manner that they are not.
But that wasn't his idea, though, right? That wasn't his idea.
It wasn't. He was initially seeking, at least nominally, an adult on the website. Skip the Games, although you do have to be 19 to create an account. There are no actual age verification procedures in place, and skipthegames.com is a website where CISA and related offenses is facilitated, as well as, and it's also, there's just been a number of cases in which CISA and CISA
But didn't the government plant this idea? Like, wasn't the government the entity that planted the whole idea of an underage person?
I think it's sort of akin to how in drug undercover operations, law enforcement might provide, say, some soap made to look like cocaine or, encased in cocaine. They are providing in essence, the contraband, but in reality, all they're doing is merely presenting the opportunity.
But wouldn't the analogy be the drug dealer walking up to the person and asking if they want to buy drugs?
No. So
Why?
they'll, it would be more, it's more similar to like a People v. Williams or People v. Butler, in which the law enforcement is placing the decoy in a forum in which they have information that the crime being investigated is being facilitated, and then they wait until someone approaches them. So that already narrows down the focus of their investigation to just people who are willing to at least seek them out. So that already narrows it down. But then further,
But in this situation, the defendant never said, I like underage women, and I like 15-year-olds. The government said that.
that's correct. But then at the point that the government says, okay, because I'm 15, all the government has done to induce the defendant or cause, beguile, any of the other terms that have been used throughout the years, all that law enforcement has done is to state their age. And simply stating someone's age is not the type of conduct that would cause or induce someone to then seek out a child to solicit them for sex.
But the age is what makes it a crime.
It is, yes.
So it's not just a fact, right? It is the thing that makes it a crime.
Yes, but they haven't engaged in any conduct that wouldn't, essentially, it would be stating that just the mere saying her age or the statement of the age would be enough for us to accept that would be sufficient to cause a hypothetical unwilling and unready person to go on and solicit the child for sex. So if because under the Michigan's modified entrapment test, under impermissible inducement, we are comparing the response of a hypothetical person who's not ready and willing to commit the crime, but who is in the defendant's circumstances. We're comparing what that hypothetical response would be to how the defendant then actually responded in the circumstance. And then that is used to basically evaluate how much inducement law enforcement actually had to engage in to cause the defendant to commit the offense, if any at all. And ultimately, it's a better determination of whether or not law enforcement was engaging in conduct in which a ready and willing person or non-ready and willing person would.
My concern on this whole situation, and I apologize for asking so many questions, but my concern with the whole situation is the whole idea of entrapment is that the government doesn't go out and solicit or encourage people to elicit or participate in bad behavior. And I guess the concern I have here is that if the government hadn't been the entity that said, well, 15, then none of this would have happened. This would never have happened if the government hadn't basically said, created the opportunity for him to do this.
Well, and that is really sort of the crux of it, is that all that they did was create the opportunity. And this court, and really courts pretty consistently going back for as long as entrapment doctrine has been accepted, is that the mere presentation of the opportunity is not sufficiently inducing conduct in order to induce someone. So
What about the fact that in this case, and I recognize obviously these are very factually specific, but not only did the police or the decoy initiate the 15-year-old comment, which, to be fair, the defendant a couple of times said, no, have to be 16. I'm cool if you're older than 15 and you want to role play to be 15. But then it was also the decoy who initiated the sexual contact, right? The proposition of sex. So it already been out there about the 15. If it was never, isn't it the 15 plus the sex? And both of those are coming from the police.
right. So obviously the record is very clear that the first person to make a sexual comment in any way was the decoy. However, because the investigation was being conducted through Skip the Games, there was already, the entire context of the conversation was the solicitation of the escort for sex. So if you look at what they're discussing before they get into discussion of the age, it's talking about, are you free, are you in pawpaw, are you available, because they are arranging to meet for the solicitation of sex to occur. So that context is already a part of the conversation. I would fully agree that if this was, say, a sting operation occurring on Facebook or Instagram, which also has an age requirement, but children frequently lie about their ages to go on those websites, and CISA and CSAM are facilitated on those sites. if there was basically this identical conversation occurred, and it was not in the context of someone already soliciting sex, I think the analysis would be different.
So what about the examples that CDM cites in its brief of these operations being, now taught and used throughout the state on completely legal websites like you're talking about, like Grindr and Tinder and that, where, he did ask her if she wanted to go out for dinner. You might go on, it's not always necessarily for
Right.
sex, right? And certainly on something that isn't billed as an escort service, like a Grindr or Tinder or Facebook or what have you. These operations are being used on those sites as well.
Yes. So with the sort of the in-between between Skip the Games and Facebook, the sort of the Tinder, Grindr, on those sites, people use those sites both to find sexual partners, but then also to potentially romantically date or engage in these other types of relationships. And so if we are examining a investigation being facilitated on one of these apps or websites, basically we can't use sort of we can't operate under the assumption that the solicitation of sex is necessarily occurring. We would have to look at what the conversation was between the decoy and the suspect to determine, was the conversation's conduct, or,
But
excuse me.
why, I get that there's a greater likelihood that Skip the Games, that the interest is in sex, but it doesn't have to be. And so why isn't it relevant, again, that it was the police who initiated sex? There could be, an extremely lonely person going on there saying, you want to have dinner instead? Do you want to cuddle? Whatever. And if the police are the ones who initiate sex, why is that not entrapment? And here, they initiated the offer of sex and the 15, and the thing that made that sex not just a crime of soliciting sex on the internet, but a 20-year felony because of under 16.
Yes, so I guess while it would be possible that, really the part of the difference is that Skip the Games, and the record supports this as well, is although it's possible there could be an outlier of someone seeking cuddling, it's pretty explicitly and solely relevant, or it's limited to the context of the solicitation of sex. And so that, I guess, by a defendant already being on that website and already approaching the decoy, he is at least engaging in a conversation knowing that this context is surrounding it. And then they're talking about where to meet up. Prior to any discussion of age, there's nothing of him saying, I just want to cuddle. There's none of that going on.
No, but I'm analogizing, like, again, to the police decoy on the corner of a high drug traffic area, right? Yeah, odds are the person walking past that might approach that person or talk to them are maybe seeking drugs, but there's also people who aren't. And even if that's a rarity, right? Like, the point is the police can't make that person, whether they're, would be willing or maybe interested in getting drugs, or somebody who isn't, they can't manufacture the crime.
Right.
So why is it, even though you're on a website that, 4 out of 5 dentists would be looking for sex, but also maybe not, right? And again, if they're initiating it, maybe that's a different case, and I understand Mr. Doman saying that is still entrapment, but that's, I guess, a different case. But why is that not the equivalent, that if here, to me, the significance is both the sex, which is the lower level crime even, and then the escalation to the 20-year felony was initiated by the police?
So I guess I kind of have two parts to how I want to respond. First, law enforcement, when they're similar to in Williams, when they're engaging, in this more general investigation into a type of criminal activity being facilitated in a specific forum, they ultimately are adjusting, or the manner in which the investigation proceeds is based primarily on how the suspect responds to the mere presentation of the opportunity. So if the defendant, if in the present case the defendant stopped the conversation, law enforcement, and the record I believe also indicates this, that the law enforcement didn't know his name, they had his phone number, but they didn't know if that would be like a real phone number. They had no information, so he was ultimately under zero pressure to completely stop communicating. But because instead of doing that, he engaged, or he furthered his engagement, and then ultimately, when without any pressure from law enforcement, decided to drive all the way to the hotel, that was ultimately, that's how law enforcement, even though he was engaging in conduct sufficient to constitute CISA by simply continuing to discuss make the plans to continue soliciting the escort for sex after knowing that she was a child. Ultimately, even after that occurs, then law enforcement doesn't plan on making the arrest after he simply tries to say, no, you've got to be 16. That's not when they do it. Ultimately, they're tailoring their investigation to only essentially arrest or go seek out suspects who are so ready and willing that they are willing to drive all the way
What
there.
happens when he says no? Can the government take the next step and say, you want to think about it? Or what happens when he says no?
So it ultimately, it is a fact dependent, so we'd have to look at everything. But if he says no and the government, I think, again, context is relevant. I think it's like the videos that CDAM provided. They mentioned that one of the potential suspects who had indicated he was going to drive to the hotel decided not to because of weather, because of the inclement weather. And so in that circumstance, it might be, and again, it would need to be evaluated under the totality of the circumstances, but ultimately, that would be evaluated differently than if the suspect simply said, no, I don't like kids, and then the government continued to try and push them. Also, too, the idea of the escalating someone's criminal culpability from the idea that is reprehensible is I'm not arguing that in the slightest, but in particular when we examine, especially when we examine cases where law enforcement engaged in escalatory conduct, generally speaking, that is when law enforcement knows that the suspect does not have the requisite criminal culpability, like in People v. Killian, where the defendant was a user of cocaine but not a seller of cocaine, and law enforcement had every reason to know. In those circumstances, the law enforcement knows that the defendant does not have the requisite criminal culpability and yet still makes the decision to target them for investigation, in knowing that they would have to engage in impermissibly inducing conduct in order to cause or induce them to commit the offense. And so that's really where the escalation of the culpability becomes a problem, is because law enforcement is making the determination that it is appropriate or that it is even a good decision to make to choose to engage in behavior or conduct to escalate that behavior. And so if law enforcement does not know what a suspect's existing culpability is, they cannot knowingly engage in behavior aimed at escalating it. And
Counselor, if we're really focused on law enforcement's conduct, and let's say it wouldn't be entrapment if they have guardrails in place, such as not raising the issue of sex, such as training the people, such as recording everything. Let's say there are standards and practices that protect the integrity of these operations. What do we do when those aren't honored? Such as in this case, where there are lapses in following the standards that are supposed to protect the integrity of this. Doesn't that suggest that we're over the line at that point? And if not, why not?
So I have two sort of parts to my response. So first, in the present case, because this was a training operation, Genesee County was basically showing Van Buren County how to conduct these investigations. There were not policies necessarily in place, so there were none that could be violated. There were not policies in place for law enforcement essentially to violate in order to induce the conduct of defendant. I know that that's not the most satisfactory answer, but there weren't the policies in place. I think it would be different if there were policies in place and law enforcement then chose to either not, to ignore those policies or to take, try to sidestep them. That would be.
Wasn't there a suggestion in the record that the officer who was involved here thought there should have been some additional checks, or there would normally be additional checks, and that wasn't present here? Isn't that the kind of lapse I'm talking about?
Yeah, yes, and most notably would be the error or the oversight that really sticks out, in my opinion. It was the oversight in failing to record the phone call. But ultimately, because we are here, we are evaluating this case under the entrapment doctrine, entrapment defense, we really need to evaluate whether these mistakes or these errors of law enforcement would amount to reprehensible conduct or impermissibly inducing conduct. And conduct needs to be reprehensible would have to be dangerous, criminal, or immoral acts, which ultimately an oversight, a failure, a mistake doesn't reach that standard of true reprehensibility that Michigan jurisprudence requires for entrapment to be established under that prong. And then also, using the failure to record the phone call as an example, while undoubtedly an error, that would have in no way induced or caused the defendant to go forward with committing the child sexual abusive activity. He had no expectation that the call would or would not be recorded, and he didn't know law enforcement was involved.
Wouldn't we know what it said and whether he was in fact induced on that call? And
we know what the
we don't know
stipulated
now?
facts state, and so the stipulated facts are fairly limited, but they ultimately, there was no indication from the stipulated facts that there was really any further discussion of sex or any inducing or reprehensible conduct occurring on that phone call. So since we're limited to the record, ultimately we have no record support indicating that there was anything untoward happening.
Would you agree, though, that the policies, whether they were in place for this conduct or not, the purpose of the policy and why the police would employ them is to avoid a situation where there's entrapment? Where a
Absolutely.
claim is going to get thrown out, right? So don't do these things because, we're going to be held to have entrapped this person and this case goes away.
Yes, and that's why excuse me, yes, those procedures generally are in place to protect against these sort of arguments or issues arising and to protect the integrity of the investigation. Ultimately, in the present case, it would have been better if those policies and procedures were in place. They just, quite frankly, weren't at this point.
Okay.
Growing pains aren't a great explanation, but ultimately this is what we are left with. Generally speaking, though, different police departments and law enforcement organizations do have policies and procedures in place. I believe Genesee County does have policies and procedures in place, and so those are ultimately there to protect the integrity of the investigation and the rights of the suspects and defendants.
Counsel, so let's take these facts here. Obviously, you believe, it didn't cross the line. What else would have to happen for this to be entrapment?
So I think we've kind of touched on it a little bit, but if the defendant, instead of, if he had said, oh, I'm not, I don't want to mess with a 15-year-old, no thanks, and they say, oh, no, come on, please, like, it's not that bad, or they were to make like a promise that, no, actually it's legal, don't worry, like any of these sort of things where basically they are actively engaging in trying to pressure or trying to, there is case law stating to overcome the will, but basically.
So he said nope, has to be 16.
Right.
So why was that not enough to say, okay, I've got to drop off now?
Because that was the exact kind of conduct that's being investigated under the child sexual abusive activity statute, because she was under the age of 18.
Okay. Okay, so for this case.
For this
Okay,
case, yes.
Fine.
And yeah.
Okay, there's a whole bunch of cases CDAM has provided us where I don't believe it's the same conduct. So, and there are examples, I think, of the defendant saying, I don't think I'm interested, but then there's still engagement. I know I'm putting you in a tough spot,
Yeah.
because those aren't your cases, so.
No, and that's okay. Again, it is a very much, because of the highly fact-intensive nature, it is a case-by-case analysis. But ultimately, it would be, including the Joulette factors, but not limited to, looking at the conduct of law enforcement to see if they were engaging in active measures aimed at basically inducing or causing the person to commit the crime. And so if you're, in cases similar to this one, where all they're doing is saying, I'm 15, they're not engaging in any conduct that would actually induce or cause someone to commit the offense. In other circumstances, if they're, appeals to friendship, appeals to sympathy, or even maybe like using extremely low prices, you could maybe make an argument for that. But those are ultimately, those are the circumstances surrounding the presentation of the mere opportunity, which ultimately was considered by both the trial court and the
So
court of
if
appeals.
the defendant here had said, sorry, not interested,
If he had said, sorry, not interested, and law enforcement continued, then yes, that would be a much clearer indication of entrapment.
thank you.
All right, and if there are no further questions,
Thank you.
all right, thank you for your time.
And we used up all your rebuttals, so thank you for your arguments. The case will be submitted.